Well, hello once again, and welcome to the Employment Law Show. John Scholes beside me, kind of, Lior Samfiru at a distance as we continue the social distancing here with COVID-19 and the coronavirus. But the show must go on. We're going to do it again this week. Lots of stuff coming up. I'll give you the contact right away that you can use anytime throughout the show or otherwise. 1-855-821-5900, employmentlawyer.ca, or help@employmentlawyer.ca is email. And for the next little while, it looks like could be a matter of weeks or months, COVIDrights.ca. There's a wealth of information there for you as well. You can go there anytime and ask questions afterwards, and we'll get to them on the radio show as well. You want to go to employmentlawyer.ca, catch our radio show, and we take questions from the show playing back here. But that's all coming up here in just a bit. Lior, I know you want to get the week that was. Plus, a little later on, our main topic for today, or at least one of them, is when to call an employment lawyer during the COVID-19 pandemic. And if this is a reflection of our recent radio shows across the country, it has been absolutely mad. Not in 8 years have we had such response on the phones, and that is why we do this show every week, my brother. So the week that was, I guess you want to talk about it, right?
It really has been a bit bonkers, John. It's been so crazy busy and dealing with these new issues and new concepts that didn't exist before. No one knew what the CERB. There was no CERB up until a couple of weeks ago, and now it's become probably the most important thing in my life, the thing I talk about the most. But there are still so many questions to be answered, still so many issues that come up with your job, with your employment, with your job security, your compensation, the benefits that you're owed. So we want to address that here on the show like we do on our radio shows. And I hope that by doing that, we can help answer some of the questions that you may be facing, some of those concerns right now. Your health and your job are going to be the most important things as you go through this pandemic. So can't do anything about the health right now. Hopefully everything is good. But on the job front, on the understanding your legal rights front, we can certainly help. So we're going to try to cover as many topics as possible. But if we don't cover your specific situation, if you have an issue or a question, something that we haven't touched on, reach out to me after the show. We'll give you my phone number, my email address. I've been 24/7, it feels like, for the past 3 weeks, answering questions, speaking with people. Don't hesitate to reach out. Now, usually in the week there was, I talk about a case or some matter that came across my desk. I'm not going to do that now. I want to talk instead just briefly about the CERB, just to summarize it for people. There's still so many questions here about what that is and who gets it. So the CERB, the Canada Emergency Response Benefit, a benefit that the government has put together that allows people to get compensation if they lost their job or if their income has been eliminated as a result of the pandemic, as a result of the virus. But what the benefit provides is $2,000 a month for up to 4 months, so for 16 weeks. Now, to qualify for that, you have to meet a few criteria. You have to be 15 years and older and be a Canadian resident. You would have had, and this is the key, to have lost your income. So a lot of people are saying, well, I'm still working, I'm just making a lot less money. Do I qualify? The answer is no, unfortunately, you do not qualify. The way the government has defined this benefit is that it's only for people that have lost their job completely, where there's no income coming in whatsoever. Now, we understand that the government is making some changes, and hopefully by the time we're back on the air, those changes would have happened. But right now, John, the government has said you would have had to lose your income completely, whether you're an employee or self-employed. You qualify, you need 14 days of no income to qualify, and you also need to have earned at least $5,000 over the past year. So if you meet the $5,000 threshold, if your income has been reduced, you can apply for the CERB benefit, and it's really the honor system, the way the government has defined it. And not only that, if you otherwise would have gotten EI, after March the 15th, you're automatically going to get the CERB benefits, and you can start getting EI if and when the CERB benefit runs out, John.
Yeah, I think the interesting point about that is, and you brought this up the other night on the radio show, was the fact that if you're still working, so I mean, extreme example, if you were making $100,000 a year and as a result of this pandemic now you make, or $100,000, now you're making $50 a week, you still don't apply. You can't apply. That's rough.
Yeah, it's rough, and it actually makes no sense whatsoever. If I've lost everything but 1% of my income, why should I not get this benefit? It's not like I can live off that. And I think the government has now realized almost the absurdity of that concept. And because of that, they are implementing some changes. But right now, if you're going to be one of those first people applying for the CERB benefit, you're not going to be able to apply or qualify for it if you're still earning income. Hopefully that gets changed, and hopefully it gets changed very quickly. But as things stand right now, only for those people that have lost their income completely.
Got it. Again, employmentlawyer.ca. Any time to reach out, help at for the email attached to employmentlawyer.ca will work just fine. You want to go there as well to catch or at least find where you can catch our radio show, our weekly radio show. As I mentioned off the top, 7-8 years we've been doing this, and man, it's helped a lot of people. We take the good phone calls from the show, we play them back here, and we talk about them. Phone call number one for today is right now.
I work for a dealership, and I'm the fleet manager. I just got told that I was getting a temporary layoff. I've never been in this position, so really I don't know what that means. They said that I would get my papers and that I could apply for EI.
How long have you worked for this company?
Over 13 years.
The old temporary layoff, huh?
Yeah, and that's probably would have been over the last 3 weeks, probably one of the most common, if not the most common question I've been getting. I've been put on a temporary layoff. What does this mean and what are my rights? Now, our regular viewers of this TV show know what I've said maybe dozens of times about temporary layoff, and that is that a temporary layoff in most cases is not legal in the sense that a temporary layoff is in fact a termination, or it gives the employee the right to treat that as a termination. The same thing happens during the virus, the pandemic. So just because the company is struggling financially, it doesn't change the law. The law doesn't get suspended, which means if you've been laid off temporarily, even though the company is allowed to continue to operate, you have the right to treat that as a termination. You don't have to. You can continue and stay on the layoff and hope to get called back to work. Or you can say, no, I'm going to treat that now as a termination today and require the company to pay me my severance. That's the option you're going to have in a temporary layoff situation. And of course, the question then becomes, well, how much severance do I get? Well, rather than me just tell you, let's plug this person's information into the pocketemploymentlawyer.ca website and see how much he's owed. And anyone can do that at pocketemploymentlawyer.ca. So let's say this person is 49 years of age. We know he's a manager. We know he's been there for 13 years. Well, he hasn't been paid any severance because the company said it's temporary layoff. But as you see on the screen, he's owed anywhere from 16 to 18 months pay. Up to 18 months pay this person is owed by way of his severance. So that's just from pocketemploymentlawyer.ca. You can go there yourself to find out how much you're owed. If you lost your job, maybe you've been laid off temporarily and you want to better understand your options. So remember, employment laws don't get suspended, and that's especially important and true when it comes to what your rights are during a temporary layoff.
You know, it's interesting, during this whole pandemic and COVID-19, if you're working for a very large multinational company, chances are, okay, you accept the layoff, you get called back to work because they're big, they've got deep pockets, and they'll get through this. What if you're working for a smaller chain or a mom and pop shop and they don't get through this and they end up losing their business? You can't claim severance, right? So what do you do? What are your thoughts?
Yeah. And this is a difficult situation and one that I've been asked many times. You know the saying, John, I've said this before on the show, you can't get blood from a stone. That certainly applies when it comes to severance. If a company is out of business, if they're bankrupt, if there's no money to be had, well, they can't pay because there's no money to be had. So the reality is, if a company is bankrupt, no severance is going to be paid, or at best, it could be a few pennies on the dollar, and that's best case scenario. So some people are in that situation right now where they're concerned about the viability of their employer. Well, they have to make a decision. Do they wait to see what happens, taking the risk that the company may be out of business, or do they consider themselves terminated now and pursue severance? That is obviously a personal decision. If you want to consider severance, if you don't want to wait, give me a call before you do anything. Let's have a sit-down discussion about your options and your rights.
You know, it's funny, too, and I thought I mentioned this before we move on to our topic, that under normal circumstances, if you accept this temporary layoff, once you go back to work, now you've given them the right to do it again. Will that change at all because of extreme circumstances of COVID-19? Like, we can forget about that first one, you can't put me on layoff again, or is it the fact that employment rights still stand and this could affect you 5 years down the line again?
It absolutely could affect you. So accepting a layoff now, even though these are exceptional circumstances, no doubt, it can still affect you. So if you're going to accept the layoff, make sure you tell your employer in writing, just so you know, employer, just because I'm taking this layoff and sitting at home does not mean I'm agreeing to any future layoffs. Make sure that that's known in writing. At least that gives you some measure of protection.
Again, reaching out, help at employmentlawyer.ca. That's the email address, or simply employmentlawyer.ca. And as you mentioned there, pocketemploymentlawyer.ca, great resource for information for our viewers. Absolutely free. It's anonymous. There's a contact button at the top right if you want to carry on from there. But topic for today, as mentioned, when to call an employment lawyer during COVID-19 pandemic. Number one is this. Your employer refuses to take you back to work from a medical leave of absence. How about that?
Obviously. So you may be off on a medical leave absence. Maybe it's COVID related or non-COVID related. Remember, employment laws don't get suspended. If you're able to come back to work and there's job for you to do, if there's work for you to do, your employer has to take you back. If there isn't work, in some situations you may not, the employer may not have work, especially given what's going on right now, that may be different. They would still have to pay you severance, of course, but at least it wouldn't be a human rights violation. If you're on a disability leave, on a medical leave, and your employer doesn't bring you back, not only could you be owed severance, of course, that could also be a human rights violation. Always a good and a very important time to get some legal advice.
We were talking about times you need to call an employment lawyer during the COVID-19 pandemic. This second one seems kind of outlandish considering that we're all doing it, including you right now. And that is your employer won't let you work from home during the pandemic. Come on.
Yeah, and employers should allow employees to work from home where possible, especially when it's the safer way or maybe the only safe way to allow work to be done. So in those situations, an employer that refuses to allow the employee to be safe, to do their work in a safe way, may find themselves in a constructive dismissal situation. They may find themselves to have terminated the employee. Now, I'm not suggesting that every employer has to allow every employee to work from home, but it's certainly a very good idea and it's good practice when that's the safest way to do the job and when the job can be done remotely. Now is not the time to say, I want to do things on principle. If you can have your employees do work from home and that's the safer option, they can do the job, let them do it. If not, and you put them under risk by having them come into work, you, the employer, may have liability. Absolutely.
How about this one? Your hours of work or level of compensation, for that matter, have been cut.
And, this may sound somewhat counterintuitive in that right now, business is not good for most companies. So what do? They cut the hours. Well, that doesn't change what the law is. Remember, I started off by saying employment laws don't get suspended. Well, what do we call when an employer reduces pay? We call it a constructive dismissal. And the same thing happens here. If your employer reduces your hours, you may have the right to treat that reduction in hours, that reduction in compensation, as a constructive dismissal. So in other words, you can accept it and continue working, or you can treat that as a termination and require the company to pay you the severance that you're owed. You only have a short time to make that decision. If you take that pay reduction and you work more than a couple of weeks, you're going to be deemed to have accepted that, and then you can't do anything about it. If you want to treat that as a constructive dismissal, or better understand that option, you really have to call me and get that advice so that you're not compromising your rights.
We are talking about the times during the COVID-19 pandemic you need to reach out and call an employment lawyer. This one speaks to probably everybody, or at least 90% of the people viewing the show right now, and that is you've been placed on a temporary layoff.
Yeah, we touched on that, and that's so important. Remember, the layoff, I'm not talking specifically, John, about situations where the business is able to continue operating. They haven't been required by government to shut down. If the business has been required by government to shut down, there probably isn't much you can do until the business is allowed to reopen. But if your business is still operating, it's deemed otherwise an essential service, but your employer, maybe because of lack of business, decides that the right thing to do is to lay you off temporarily, remember, that's not an automatic right that a company has. In fact, most employers do not have that right. You can still treat that as a termination. That may be something you want to consider. Maybe it makes sense financially to do that to get more compensation now. You may not be able to live off EI or CERB. So if that's your situation, the first thing you do is you get some advice. You don't go to your employer and you say, I'm out of here. Let's sit down. Let's have that chat before you do anything else.
One more of these before we break. Last one on this topic, and this is the big one. You've just simply been terminated from your job.
Yes, that's when you call me. There's no hesitation. There's no second thoughts. You tell your significant other first, you call me second without exception. Severance rules apply. If you lost your job, whether it's COVID related or it's not COVID related, if it happened right now, you have your severance and termination entitlements. And remember, the same rule applies, as I've always said, that 90% of people, maybe more than 90% of people, when they're let go, are not offered anywhere near what they're actually owed. Don't believe me? Go to pocketemploymentlawyer.ca, input your information, take seconds, free, anonymous, and find out what you're owed versus what you've been offered. And I assure you, you'd be very, very surprised. If you want to talk about what you're owed, if you lost your job, you know what to do. You reach out to me. Happy to help you.
Really simple. As we go into break here, I'll let you know how to do that. 1-855-821-5900. help@employmentlawyer.ca or simply employmentlawyer.ca online to find where you can catch our radio show, from which we'll pull another phone call and do that as soon as we come back here on the Employment Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru, as always, giving you the information you need at this possibly the most important time that we've had this show in the air. Same goes for our radio shows as well. You want to reach out, it's employmentlawyer.ca. And for the next little while, another good place, robust, lots of information there, COVIDrights.ca. You can go there anytime you like. And the phone call, of course, 1-855-821-5900. As I mentioned, Lior, we're going to get to phone call number 2 from the radio show and dissect it. We'll do that right now.
I'm self-employed. I've been doing this business for many years, and this one particular client represents 70% of my business.
Right.
I asked for a record of employment because they said they would have to cut me off. There was no work to continue. They said, no, they couldn't do that because I'm not a salaried employee, rather.
Aha.
Yeah.
I know what they're calling them.
They're calling him an independent contractor, but he's probably not that. He's probably not actually an employee either. He's probably what we call a dependent contractor. So what is a dependent contractor? A dependent contractor is someone that's not quite an employee and not quite an independent contractor. A dependent contractor is someone that is self-employed, but because they financially depend on one customer or one client, that customer or client has obligations to them. And specifically, they have the obligation to pay them severance if they end the relationship. So this person says that he gets 70% of his income from one customer. Well, that's financial dependency. If he loses that customer, that's a big, big deal. So if the customer wants to end the relationship with him, whether it's COVID-related or not, they have to pay him severance. Essentially, they have to pay him the same severance as if he were an employee. So he can go to pocketemploymentlawyer.ca. And by the way, pocketemploymentlawyer.ca also has a tool, again, free and anonymous, that allows you to find out if you're an employee or an independent contractor or something in between. So you can do that for yourself. But this is a very common situation. People may not appreciate or understand that you could be self-employed, but still have rights to severance. Now, beyond that, because he's self-employed, if in fact he's not going to be earning any income, he can also apply for the CERB benefit because it does apply to self-employed individuals. So he can do the CERB benefit. He can also get severance. So yes, there are options and there are rights even for those that are self-employed.
You know, I saw the prep sheets for today, and I saw this independent contractor quiz, and I thought, oh, great, he's putting me to the test again, which you'd like to do every few years and make me look really small. But I noticed I have the answers here as well, so I'm just going to read these. We're going to talk about them, and at the end, we're going to see what happens, right? So, independent contractor quiz. Number 1 here: do you exclusively work for one company?
So this quiz, really, it's the type of questions that I would ask someone to find out if they're an employee or an independent contractor. So the first one is this: do you work exclusively for one company? Because if you do, you're likely an employee. Someone that's an independent contractor, that's self-employed, usually, not always, but usually has more than one customer. They work for as many as they can, 1, 2, 3, 10, 20. But if you work for one company exclusively, then guess what? You are likely to be an employee of that company, regardless of what you may believe or the company may believe. The law may deem you to be an employee.
Question number 2, do you set your own hours? How about that one?
So if you decide when you work, how much you work, then you're more likely to be an independent contractor. On the other hand, if you're following someone else's directions, you have to work 9 to 5, Monday to Friday. Those are your hours. Well, guess what? That kind of looks like employment, doesn't it? Well, that's why you're going to be likely an employee. An independent contractor sets their own hours, whereas an employee has their hours set for them by someone else. So if you're having your hours set, you're very likely to be not an independent contractor and instead be an employee.
Do you have to pay all the expenses associated with doing your job? How about that one?
If you're paying expenses yourself, more likely to be an independent contractor. If someone else pays those expenses for you for doing the job, if you're not spending really anything out of pocket, you're almost always going to be considered an employee because you're not really taking a financial risk. So that's a huge factor, John.
Last one here of our independent contractor quiz. If you haven't figured it out yet, here's one. Have you been working for the same company for more than 6 months?
Yeah, generally, if you're more of a long-term person working for a company, you're going to be considered an employee. An independent contractor is usually, not always, but usually someone that's there for a limited time, either for a specific project or to cover for a defined period of time. If you're working there longer term, it's been more than 6 months, it's been a year, 2 years, 5 years, guess what? You are going to be very likely an employee. Now, those factors that we've just talked about, the ones that John and I have just discussed, there's not one of them that in itself determines if you're an employee or a contractor. Right. We have to look at all these factors, and we assess all these factors. I can always say, yes, you are an employee, or no, you're not. And why do we care? Well, it's obvious, because if you really are an employee, even though you think you're an independent contractor and the company says you're an independent contractor, well, you're owed overtime, you're owed vacation pay, holiday pay, you're definitely going to be owed severance if that employment comes to an end. You need to understand that. And it's important now in the COVID situation, because the company that you work for may say, well, you're an independent contractor. We can just end the relationship with you and not pay you anything because you're not an employee. But if the law considers you to be an employee, then you have rights, you have entitlements, and those entitlements can be very significant. And by the way, pocketemploymentlawyer.ca, the easiest way to find out immediately, literally instantaneously, if you're an employee or an independent contractor.
Plus, if you've been misclassified or classified yourself as an independent contractor for years and years, the old tax man could come a-calling, and that could be a big roll of wrong right there.
I wouldn't want to be in that situation, that's for sure. If you're telling the CRA that you're an independent contractor and you're deducting things and it turns out you're an employee, not a good thing. So you really want to get this right. Both employers and employees, companies and individuals should all want to get this distinction correctly.
Still sound confused? Reach out 1-855-821-5900, employmentlawyer.ca, or tune in to our radio show every week. Get some answers there as well. Phone call number 3 from the radio show. We're going to play it right now.
I've been off work for over a year on long-term disability because of heart issues. Now I'm doing better. My doctor okayed me to go back. And then the COVID thing happened. They wouldn't want me to go back because of the heart issues too at this point. And I work with seniors. I'm just wondering, is the long-term disability, the people there duty-bound to keep paying me because of the situation with my heart and so on?
It's a common question, and I've been on disability. I was ready to come back to work. Now my doctor says I shouldn't be going back to work. Either something's changed. In this case, we're dealing with the COVID virus, and the doctor feels you shouldn't be going back to work. Well, here's the thing, and you've heard me say this, you've heard my partner, Tumarkin, say this on the Disability Law Show, and that is that your insurance company should always follow what your doctor says. If your doctor, the person that knows you best, the person that has the most information about your medical condition says you cannot and should not work, that should be enough for the insurance company, and they should be paying you and allowing you to stay on the benefits so that you can get paid. That also means that your employer cannot penalize you for not coming back to work if your doctor is saying you shouldn't be working. And by the way, John, I want to make the comment that you may right now be suffering from anxiety or stress, and that may impact your ability to work. If your doctor agrees and feels that you cannot work because of this current situation, many of us are experiencing it right now with COVID, then if the doctor provides you a medical note, you can be off work, but you can also apply for the disability benefits through your employer, short-term disability and long-term disability. It all starts with your doctor backing you up.
We'll slide in another phone call after a short break. In the meantime, covidrights.ca, a good place for a resource for you to check that out anytime. help@employmentlawyer.ca through email. And the phone call, 1-855-821-5900. Right back with more of the Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, good to have you stick around with us here. Employment Law Show. You want to reach out is 1-855-821-5900, employmentlawyer.ca. For the next little while, covidrights.ca as well. I think we got time to squeeze in probably another phone call, Lior, from our radio show, so we'll do that right now.
Our company has laid off about 100 people, and those of us that were lucky enough to not be laid off, we've taken a rollback in our salaries, and that was about a week or so ago. And now the company put a memo out saying that they're not going to be contributing to our RRSPs, like they match in our RRSP contribution. I'm just curious, if I said no to that, can they let me go? Am I entitled to severance?
Yep.
So another very common situation, especially now, companies saying, well, we have to make some changes. We're going to reduce your pay. In this case, we're also going to stop paying to your RRSP, and that's your situation. Well, the question was, if I refuse, can they let me go? Well, the answer to that was almost going to be yes, always, simply because an employer is allowed to let you go at any time and pretty much for any reason, as long as they pay severance. So could your employer let you go because you refuse a change? Yes. But that does not deprive you of severance. That would be a termination without cause, which means, yes, you get your full termination and severance entitlements. That said, keep in mind, if your employer says, we're going to make a change, and you say no, if your employer backs off, that's fine. If they say, well, too bad, I know you said you're not going to accept it, but we're going to do it anyway. We're going to reduce your pay either way. Well, if that's what happens, you now have the choice to either accept that reduction, continue working, and that becomes, I guess, your new reality, or you can treat that as a termination and require the company to pay you severance. You always have that option if the company implements a change contrary to what you've wanted and what you've agreed to accept. So that is always an option. But if you are let go, remember, the fact that you were let go in itself is not illegal. What would make it illegal is if you did not get the full severance that you're owed.
Last minute or a minute and a half left to go here, pal. Final thoughts on COVID-19 and your rights. What do you think?
You know, this virus, unfortunately, is not going to be going away next week. So we're going to still see some struggles with businesses having to make changes to adapt. We're going to potentially also see the list of essential businesses narrowed even more so that less businesses can stay in operation. That may mean more people are going to be laid off. My hope is that as many people as possible can qualify for the CERB benefit, that the government changes the qualification so that more people can qualify, including those that may be earning less money now, but are still earning some income. And of course, you always have the right in a layoff situation, if the business is still operating, to consider this as a constructive dismissal if you want to. Do that if you think that's the right thing for you. Call me. Always happy to talk, answer as many questions as possible. Now more than ever, there's really no such thing, John, as a bad question.
Good stuff. That's it for this week. You want to reach out to Lior, no problem. covidrights.ca, good website, 1-855-821-5900, 5900 rather, and employmentlawyer.ca. Put help at in front of that for the email address as well. We'll catch you next week. Stay safe, stay apart, and good luck. We'll catch you next time, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.